The legal system has sent a strong and direct signal. Someone who used to be president doesn't get endless protection just from having held that job. All the pushes for total immunity, for full freedom from any blame, or for dragging out court fights forever have been firmly turned down. Right now, we're seeing a key moment in U.S. history. An ex-leader is dealing with real, heavy legal fallout. The appeals court in D.C. put it straight. Being in the top spot doesn't put you out of reach from the rules. Today, the basic ideas that keep leaders in check are under close watch. When people with big influence start thinking they can dodge results without end, the setup that keeps government fair begins to weaken. The whole framework of divided authority relies on the main belief that all must answer for what they do. Still, ongoing tries to skip out on blame have stretched the courts to their edge. Folks across the nation are paying close attention as judges and lawyers strive to maintain fair standards. Several probes are advancing at once, covering accusations of money wrongdoing, blocking official work, schemes to flip vote counts, and dodging taxes on purpose. Advances in any of these will influence how officials act for years ahead. The choices coming up will define standards for those in charge long term. One main fact is clear: Donald Trump is facing a wide and grave set of criminal accusations. These aren't small matters. The chance of real jail time is quite possible. This ex-president is in the middle of a court fight like nothing before in the country. Judges in different places have stressed that wide immunity ideas have clear boundaries, and plans to skip hearings have not worked. Prosecutors at federal and state levels are pushing on with focus. Each matter holds a real risk of time behind bars. The claims go from trying to mess with confirmed election totals to getting in the way of justice, concealing earnings from tax officials, doing shady business deals, and mishandling secret state files. If shown true, any single one might bring a guilty verdict. Together, the possible punishments could total many years. The D.C. appeals panel was direct. No ex-president has a forever pass from the law. Thoughts like facing arrest, going to trial, and getting sentenced have moved from just ideas to very likely. Seasoned legal pros say the proof collected so far seems solid, and endless hold-up efforts probably won't win. Courts have also shut down the option of a pardon given to oneself. The call was simple: no one in charge can erase their own mistakes. That choice took away what lots saw as his final big court safeguard. Federal accusers are set to act fast once any leader's shields are gone. Whether by finishing a term or through other court steps, judges are clearing hurdles one by one, opening a straight route to hearings, and if guilty findings come, to doing time. Folks who've followed him near say he gets how bad it is and has shown true concern behind closed doors. With every fresh update, the dangers grow wider. A mix of huge civil suits calling for big payouts and layered criminal matters in various spots means success in one doesn't fix the rest. Accusers from different groups are teaming up to block any last ways out. Judges have also ruled that details from Congress impeachment sessions can back up criminal matters. This tie makes dodging much tougher. Courts keep okaying calls for papers, looking over big stacks of proof, and saying no to bids to stop or drop cases. Meanwhile, tough money strain is rising. Big civil fines, like one in New York close to $500 million, are already set. Holdings are getting taken, funds locked, and items sold to follow court commands. This growing cash lack makes building a solid fight harder. The twin issues of likely jail and fading funds make a hard spot. The court process goes on with steady drive, showing that even folks who once had top power must play by the same guidelines as all. Each judge decision and move ahead builds the argument against him. The issue isn't if lockdown might occur, it's when. His old job gives no ongoing cover. Choices from earlier times are now under sharp review. This setup creates a vital example. No one, regardless of past role, can avoid results forever. Time in prison isn't a far-off thought anymore. Increasing numbers of watchers see it as a true and rising chance. All this is shifting how people in the U.S. think about true answerability at the top of power. Ideas of pardoning oneself have been flat out denied. Courts have strongly decided that a leader can't clear their own deeds. The concept of giving full forgiveness for one's own behavior goes against main founding rules. Judges made it plain. The pardonability is for offering grace to others, not guarding yourself. Any wrongs before or while in the role stay open to charges. That choice cuts out a main piece of the plan he counted on. He appeared to believe a self-pardon could wipe out all federal dangers. The D.C. appeals group said right out that no law backs it. No words or paper can build an unbreakable wall. This lets accusers draw on proof from his term. Claims tied to money tricks, blocking probes, tax problems, and vote meddling stay live. Experts on the founding document call this a key clear-up of basic bounds. It backs up a core rule. No one can be both the offender and the one who forgives. The decision opens the road for ongoing and coming cases. Proof from impeachment looks, secret files checks, and national wrongs can go ahead without blocks from immunity calls. Every solid claim is ready to advance. The choice makes sure tactic plays can't weaken fairness. Wide immunity pushes have lost ground. The self-pardon notion is off the table. Pushes for endless immunity have been turned away. Several courts have found that calls for full safeguard for leaders don't stand. The idea that the top job makes a forever or complete block against charges has been denied in many decisions. Judges have kept pointing out that such guards aren't without end, especially for big wrongs. Bad acts while in the role, like cheating, blocking fairness, or messing with votes, can face charges after stepping down. This outcome cuts a big part of the defense plan. For quite a while, his court team relied on the job as a firm wall to push back or maybe skip blame altogether. The D.C. appeals group cleared up the lines. No current or past leader is free from crime rules, especially when deeds could lead to removal. This is a firm court message. Guards linked to the position don't include personal bad acts. Judges have held that steps done with official weight can still be checked, and immunity can't halt charges. Pros in the area see these choices as a big change from past thoughts on leader guards. The real result is basic. After leaving the spot, by term end or other ways, the person turns open right away to accusations. Accusers can move without limits, and hearing courts are set to go on. Tries to use old official standing to hold up, stop, or close matters now meet tough pushback under set law. The effect spreads past this matter. These decisions as a group show that coming leaders will deal with the same close look, affirming the court's key part in stopping possible misuses, no matter the level. Judges have also said that earlier immunity pushes, whether for more check time or other guards, don't keep fairness from advancing. The main idea is plain. Top position doesn't give personal freedom from results. Claims involving money, votes, or state papers can bring charges once out of the roll. The fresh choice from the D.C. appeals group has basically reshaped the court scene. The Federal Review Panel in the Capitol has given a decision with deep effects for Donald Trump and the wider topic of making current and ex-presidents answer. The court said clearly that many good routes for charges stay open at national and local levels, and immunity or self-pardon calls have no base. This counts a lot. It boosts the founding split of authority and spotlights the court's job to curb possible excess by the leader branch. The group noted that claimed deeds with cheating, blocking, vote meddling, and other grave issues stay open to charges no matter old spot. A key piece of the decision dealt with how proof from removal reviews links to later crime matters. The court said stuff from Congress checks, including any calls for crime action, can be drawn on by accusers without immunity stopping it. This turns down the thought that a leader or ex-leader could skip crime blame just because deeds blended official tasks with choice calls. The appeals group also handled times and steps. It stressed that neither proof amount nor issue hardness lets for non-stop holds. Fair hearing rights stay, but they don't give a pass to skip check. In action, this clears the path for matters over a broad span, from the big civil cheat issue in New York to national checks into vote behavior, blocking claims, and dealing with secure items. If guilty calls happen in a few spots, the added jail time could hit unseen highs, with some watchers saying tens of years. The group also backed that the ground for these claims seems strong, and past immunity or self-pardon pushes can't legally halt them. The decision takes out the final big blocks he might have hoped for. It gives a straight note to backers, lawyers, and everyone. The rules still count, even for an ex-holder of the top spot. By deciding that top position gives no lasting hide for personal faults, the Capitol Appeals Court has made a long-term guide. It offers direction for how future teams must deal with grave wrongs at the peak. The choice backs the court's part in watching answerability for strong folks and restates the basic fact that no one stands over the rules. A wide span of grave crime claims stays live. Donald Trump deals with an oddly long roster of crime probes and blames at national and local spots, each with chance for hard hits. The claims span money cheat, blocking fairness, meddling with vote setup, wrong dealing of secret info, quiet money deals, and several spots of claimed tax skipping. Each matter has its own pace, but as a group, they make a huge court test. Accusers in various areas are lining up so proof from one can aid others. Judges have okayed sharing thousands of papers outlining claimed wrongs across types. The New York civil cheat matter focuses on claims of way overvalued holdings and fake money reports, with possible jail spans up to tens of years in linked issues. Calls tied to quiet money deals include many serious counts that could pile on more time. National blocking claims, especially around papers and safety, could boost hits if kept. Vote meddling checks, including pushes to change checked totals, bring big results, possibly with group plot claims. Tax blames include big unreported earnings over many years, each ready for own charges. Pros who know these matters say that if guilty calls come in key spots and punishments run one after another, the full time could go past a full life. No past or current leader has dealt with crime risk at this level. Folks near the setup say he fully sees the size of these dangers and waits for things to speed up once any left guards drop. Judges have always ruled that the peak spot doesn't make a forever stop against charges for personal acts. All main blames stay active. If courts pick one after another punishments, which can happen given the range and weight, the total hit could be massive. The D.C. Appeals Group has cleared doubts about these pursuits being valid. It decided that after stepping down, immunity doesn't count, and every strong claim can be fully charged. Given his years, court watchers note that even one long span could mean life in lockup. Several one after another times boost the odds of forever behind bars. This tough fact tests the prior idea that riches, links, or old top spot could give ongoing skip from results. Court sessions will advance in a set way. Guilty calls aren't just doable. Many think them probable in different courts. Judges have backed that the whole range of claimed wrongs stays chargeable. Fair guards will count, but they don't stop lockup on proof of fault. Removal-linked proof is now okay to use. Stuff and suggestions from Congress removal checks have been ruled fully drawable in crime sessions. The National Review Court in the Capitol found that content from lawmaker reviews can shift straight to accusers. Court teams can draw on those suggestions without immunity or self-pardon blocking. Big topics from removal, blocking, money wrongs, and vote-linked deeds now steer crime matters. Lawmaker groups collected wide proof, and accusers are set to use it. This makes a straight tie from lawmaker watch to crime push, making sure answerability crosses areas. The decision promises that step objections won't halt claims. As removal issues close, linked crime matters can push on, adding fresh proof and earlier spotted wrongs. Founding scholars say this link between lawmaker and court answerability boosts full checks. No official, regardless of strength, can draw on spot or holds to skip fairness forever. Straight using removal findings in crime issues greatly boosts the chance of true results. Tough money strain is building up. The ex-leaders' business sides are under rising push from big civil hits, holding takes, and short funds. A New York civil call near $500 million is live, straight hitting properties and money movement. Ready cash for work is falling fast, making it hard to pay for wide court guards. Court commands have called for selling and shifting holdings to pay debts. This getting worse money setup adds to the crime dangers, making a joined crisis. Likely time in jail next to wearing down of riches and items. If civil hits and crime guilty calls both hit full, outcomes like broke status, big holding loss, and money fall become very likely. The growing hard of paying for court work weakens the guard and raises full risk. Folks with no in like spots say the joined load of crime matters and sharp money blows makes a tough place with few ways out. The layer of claims, civil prices, and quick holding drop shows how answerability can bring right now real effects even at the peak. National crime hearings are nearing. Court times in many areas are coming for Donald Trump. National and local accusers are setting paces and dealing proof to keep advance toward hearings. Matters with money cheat, blocking, vote meddling, and secure items dealing are all ready for close once any start steps end. Judges have noted that added time will be short, and proof size won't back non-stop pushes back. Courts have called for following calls for appear, paper asks, and other duties. These hearings will pull huge focus. News spread and public talk will hit levels seldom seen in U.S. court past. A decision or big shift in one matter will shape views, country chat, and tied issues. Hearing judges are dealing each with right weight, keeping fair and free. Proof is ready, sides are set, and needed info is swapping. Most national hearings are waited to begin after any leader guards close. Accusers are striving to skip needless holds while keeping matter whole. Court scholars call these coming hearings historic in range and possible long effect on U.S. running. The fresh D.C. review decision took out main court walls by turning down immunity, self-pardon, and hold tactics. Each hearing builds to possible guilty and lockup. The basic rule stays plain and strong. No one, no matter old spot, is over the rules. Judges have said again and again that an ex-leader can deal with claims, hearing, guilty, and jail. Having top authority doesn't make personal freedom. Blames crossing cheat, blocking, vote meddling, and tax breaks are all chargeable. Court choices have one by one broken down each big guard point, whether on immunity or self-pardon. The fairness setup advances even, steady, and firm. Accusers, judges, and lawmakers are doing their founding jobs to make sure equal rule use. This time sets a mark that will steer coming leaders. Any power misuse now brings sure later results. The setup with Donald Trump shows that the courts and rule strength last, even against ex-holders of the top spot. True outcomes include hearings, guilty calls, big civil hits, and the very possible chance of jail. The newest decision from the Capitol Review Court has shifted that rule from idea to fact. Every solid blame of wrong, regardless of the person's past level, now deals with full court check. Judges have put it straight. There are no forever freedoms. Old high spot doesn't give ongoing guard. These choices make a frame for dealing future wrongs, boost rule-based running, and back that results count for all. Grave crime claims, holding gives up, and jail dangers have turned real and close for any ex-leader who breaks standards. The note is basic and full. No one is over fairness. The court setup has changed firmly. Immunity and self-pardon pushes have been dropped. Judges have cleared step walls that could have been drawn on. A broad group of heavy blames stays live. From money cheat and blocking to vote meddling and tax wrongs, both civil and crime results keep piling. The setup has shown its power and shown past weak spots. Years of pushed-back answerability showed holes in watch. But the courts are now moving with drive, showing that no one, not even an ex-president, skips its hold. Court thinkers, including names like Glenn Kirshner, have long said that power in politics doesn't wipe legal duty. The impacts go way past one person. Coming leaders will work under the guides being made now. Past holds in answerability let issues build and tested setup guards. Many wait for next teams to deal with much tighter look, with any try to bend rules meeting fast and strong fight. This growing set of claims and hearings will reshape base parts of how U.S. running works. Keep up on these key court shifts. Sign up for steady updates. Each decision, each session, and each fresh bit will count for years. The power and even of the rule's strength are under check right now, and the result will define the country for times ahead.